Statements by Dr. Reiner Füllmich on the status of the criminal proceedings before the Göttingen Regional Court. I am now publishing 4 statements in writing that deal with the 4 central issues of these proceedings against me. I have already summarized each of these statements in a few sentences orally. I am publishing them so that anyone who wants to know exactly what is going on can find out the details and also counter those who are working with false information and, if necessary, simply hand over the written statement. Statement 1, the abduction disguised as a mock deportation. Using the deportation order from the Mexican migration authorities, which is even in the file but was not translated into German due to procedural irregularities, I explain here that the only basis for deportation mentioned there, Section 144 of the Mexican migration law, clearly does not apply. This is because Section 144 is the only basis for deportations from Mexico, but none of the 6 possibilities for deportation listed there apply. My wife and I have neither entered the country with false documents, nor have we entered the country illegally after previous deportation. Nor have we been convicted of any crime that jeopardizes national security, nor are we under investigation for such a crime. This means that my wife and I were in the country completely legally. We have not committed any criminal offenses there either. The rest of the file proves what the dossier confirms, namely that the German services, particularly the BKA and the Lower Saxony LKA, in collaboration with the Göttingen Public Prosecutor's Office, which was bound by instructions, controlled. Asked the migration authorities in Mexico to fake a deportation so that I could be abducted in Mexico and then arrested at Frankfurt Airport. The services and the Public Prosecutor's Office could and should have requested my extradition in order to be able to arrest me legally in Mexico, as they themselves confirmed by email. But since I was only accused of one offense, because it was obviously not possible to put together more, it is questionable whether that would have been enough. But above all, my lawyers and I would have been heard by the Mexican authorities as part of extradition proceedings. And this would have revealed in Mexico what has now come out in the proceedings in Germany, but which the court is trying to conceal, namely that the accusations leveled by the Public Prosecutor's Office were all false and fabricated. In particular, it would have emerged that the entire operation was controlled by the Federal Office for the Protection of the Constitution, as is also evident from the file. Extradition would then never have taken place, and the German services and authorities would have been internationally disgraced, as is now happening through these international publications. Statement 2, a timely and full hearing is the central prerequisite for. Statement 4, freedom of opinion, expression and information in the affair trial. Fight for justice. Here I explain that the Public Prosecutor's Office deliberately refused to grant me legal. With this statement, I am making it clear that the chairman's assertion that we not hearing for more than a year and 3 months on the instructions of the services, but at the allowed to defend ourselves with harsh words, including accusations of obstruction of justice same time was in constant written and verbal, telephone, contact with the complainants. Against the court and the Public Prosecutor's Office, is wrong in accordance with established Supreme Court case law. I was only given a legal hearing 1 month after the indictment was written and 3 months after my abduction from Mexico and imprisonment in Germany, far too late. However, for it is precisely when the state and the courts themselves have created a heated investigation files wherein are incomplete, I have not actually had the opportunity to properly atmosphere, hear, abduction, denial of the right to be heard, withholding evidence, faking a comment on the accusations to this day. All notes from at least 80 telephone conversations. Criminal offense, exchanging facts in order to reach a verdict against me without a hearing on and various documents relevant to the decision are being withheld. The new facts, it must be possible for the defendant and his lawyers to defend themselves with clear, unambiguous words. For this case law, I refer to our own mass proceedings. The Public Prosecutor's Office is therefore withholding important, decisive information, just as against fraudulent banks and corrupt judges, which have been going on in the German courts it did in the criminal proceedings against the U.S. actor Alec Baldwin, which led to the for 26 years and have been accompanied by the mainstream media. This is because these immediate and final dismissal of the charges against Alec Baldwin in the state of New Mexico. Legal disputes form the basis for the very far-reaching defense options in the constitutionally in the USA. In view of the dossier and the overall behavior of the public prosecutor's office. Protected, fight for justice, which Supreme Court case law grants to the parties involved in as well as the extremely close cooperation with the complainants, it can be assumed that a trial, but in particular to a defendant in a criminal trial. Instructions of the services and the theft of the money from the sale of my property, which was intended for repayment to the Corona Committee, were discussed and that the whole. In the course of those legal disputes, it came to light years later and was reported years later thing had therefore not found its way into the files. Not only by the media but also by the most important German legal journal NJW that the highest judges of the Federal Court of Justice had secretly made agreements with bank representatives to the detriment of our clients in return for payment. Statement 3. Infringement of the law through the arbitrary exchange of facts and the denial of the right to be heard. Introduction. In my opinion, the conduct of the presiding judge and public prosecutor John, as well as the other public prosecutors involved, Rika and Dr. Kutzner, constitutes the criminal offense of obstruction of justice pursuant to Section 339 of the German Criminal Code, StGB. Because on May 17, 2024, presiding Judge Schindler issued a so-called procedural order to the fifth after the facts charged proved to be lies by the complainants, the proceedings against me. Grand Criminal Chamber of the Göttingen Regional Court, consisting of 5 judges, 3 should have been dropped and I should have been acquitted and released immediately. Professional judges and 2 lay judges or lay assessors. This was his first open but instead, the presiding judge replaced the accused facts in May 2024 with new facts that were unconstitutional attempt to undermine our defense work. This was done with a mixture of obviously just as falsely invented, this time by the presiding judge himself. The so far at barely concealed attempts at intimidation, deliberately false allegations and condescending least declared refusal to hear the witnesses named by us to refute the invented facts. Statements to the defense and the public, whom he considers unable to understand what is competes the obstruction of justice. In addition, the presiding judge, as he has just stated in happening in these proceedings. An order dated July 12, 2024, but as we also explained in detail at the hearing, is now also aware that the public prosecutor's office had me kidnapped in Mexico and faked a. He also claimed, without providing any evidence, that the defense was influencing the public deportation. He also knew that I had been denied my right to be heard and that decisive. In such a way that he was receiving telephone calls and emails in an attempt to influence the evidence had been and was being withheld by the public prosecutor's office. If he continues. Court's decision-making. Now and the other members of the court go along with this, they are all guilty, especially the public prosecutor, of course, of obstruction of justice, a crime punishable by at least 1. It seems impossible for calls from outsiders to be put through to the chairman at all. If their year's imprisonment, in order to put me behind bars for a fake defense. Are any such emails or, as the chairman claims, even anonymous threats, it must be determined who sent them. Similar behavior has since been reported by the complainants. Obviously, the court and the public prosecutor's office, which is bound by instructions, are now doing everything they can to prevent the true facts of the case from becoming known. This culminated on July 31, 2024 when the presiding judge, in violation of the constitutionally guaranteed principle of orality and the principle of publicity, ordered that the proceedings should essentially be conducted in writing, i.e. without the public present being able to see and hear more than the handing over of paper. And, without the defendant himself being able to recognize which requests are being made by his lawyers. Inevitably, he is only informed about this afterwards. In particular, he did not allow Vivian Fischer's lawyer Grossenbach to speak, nor did he allow the defense lawyers to read out the motions and their grounds that lawyer Grossenbach had submitted for Vivian Fischer. In my opinion, he and the court thus finally crossed the line into the violation of the law. In my opinion, the goal of the Office for the Protection of the Constitution seemed to be the destruction of the Corona Committee and the theft of the Corona Committee's donations. Vivian Fisher may also have realized this in the meantime. Since we never agreed otherwise, I expect that Vivian Fisher would testify as a witness that, contrary to the court's invention, there was no agreement between her and the defendant to the effect that the loan agreements were mere sham transactions without binding effect in order to conceal trust agreements allegedly concluded to hold the donations in another account. Because the company for which the complainants Antonia Fisher and Justice Hoffman claimed to be acting never existed and never held any assets, the complainants Antonia Fisher and Justice Hoffman could not have suffered any financial loss at any time, and therefore the defendant should be acquitted. As Vivian Fisher and her lawyer Grossenbach rightly argued. At the end of this introduction, I will make a summarizing oral statement on the 4 central points that justify the suspicion of obstruction of justice individually, but even more so in their entirety. In order not to bore anyone, but to give anyone interested the opportunity to find out about the details and thus, if necessary, to be able to counter the false allegations being circulated by the services, we are publishing the details in writing in German and English. We are relying on the help of our supporters for the English translation because I have to concentrate on my defense in court. Before I give the verbal summaries of the statements, please allow me to make one more comment. Of course, some of the parties to the trial studied law, as the presiding judge remarked patronizingly and scornfully. This is also easily recognizable in the case of some of those involved in the trial. But I am no longer sure to whom this actually applies. In any case, I claim that I studied law not only in Germany but also in the USA and that I have also taught law at various universities in Germany and abroad. I have a genuine, I.E. not plagiarized doctorate in Germany and a Master of Laws, i.e. a Master of Laws, in the USA. I also passed the 3-day bar exam in California in 1993. I have over 30 years of experience as a litigator in both Germany and the USA, working almost exclusively in the area of consumer protection and the protection of small and medium-sized companies against invariably fraudulent international corporations. As part of this work, I was involved in 2 class actions. Most recently, this involved a class action pending in Southern California against Deutsche Bank in 2017. Action with a value in dispute of $85 billion. I worked pro bono, that is, without asking for or receiving any money, by informing the court through a so-called amicus curiae brief that Deutsche Bank regularly not only negligently violates applicable law, but does so intentionally, for example, by committing systematic litigation fraud in German courts in order to win cases by lying. 2 or 3 weeks after my brief and after I had reported on it at Deutsche Bank's annual general meeting in front of the entire management board, the entire supervisory board and thousands of shareholders, Deutsche Bank suddenly settled on terms that have not yet been made public. I wonder why. In addition, I can also look back on a number of legal publications in German and foreign publications, but I also have non-legal life experience as a soldier and as a banker in the corporate client business of Deutsche Bank in Tokyo. All of this is evident from my curriculum vitae, attached, but also, as far as my work as a lawyer is concerned, from numerous TV and press reports. The curriculum vitae is published here. In short, against this background, there should at least be a factual presumption that I have more than just stupid legal knowledge. However, it remains questionable to what extent such a presumption also applies to other parties involved in the proceedings. To conclude these introductory words, I would like to take the liberty of referring to Chairman Schindler's reference to the offense of obstruction of justice, which I will discuss in more detail later on. This offense can also be committed by public prosecutors and lay assessors. And a punishable attempt to obstruct justice can also exist if, and I quote para. 21 of the Beck Online Commentary on the Criminal Code by Heinz Heinegg, Kudlik, 60th edition. As of January 2, 2024, member of a collegiate court, namely Mr. Schindler, unsuccessfully attempts to persuade other members of the collegiate court to commit an act of obstruction of justice. However, if they join in, then the attempt becomes an accomplished violation of the law for the instigating judge, and all participating judges are guilty of accomplished violation of the law. One more thing, or one more thing, as Columbo and Steve Jobs used to say, the obvious violation of the law here is of international significance in several respects. Because this staged action is about preventing my international work. And, I was abducted from Mexico. i.e. from abroad, as I will explain in a moment. In view of the fact that the abduction was irrefutably documented in the files, an international court, namely the common law courts, intervened in England and not only ordered my immediate release due to the lack of jurisdiction of the German court resulting from the abduction, but also awarded damages in my favor. This is proof that justice, when it is perverted by systemic courts, is also and perhaps only possible outside the system of justice, if the people want it that way. It is not surprising that Chairman Schindler refers to the court as a self-proclaimed court. However, this court is a genuine common law court, which applies the genuine, original common law, i.e. natural law, exactly the same law that was applied to the perpetrators in the Nuremberg trials after the collapse of the Third Reich. Was that also a self-appointed court? Justice will prevail simply on the basis of the true facts brought to light, and without legal gobbledygook obscuring the view of right and wrong, and good and evil, and also without procedural rules being misused to simply obscure the true facts. Everyone will have to pay a price for what they have done. How high the price will be depends solely on what the perpetrators have done and what they continue to do until the day of reckoning comes. Because justice is what the people recognize, not what the corrupt system constructs. The abduction ordered by the German authorities under the supervision of the Office for the Protection of the Constitution and the concealment of the abduction by means of a mock deportation. The chairman's assertion that there was no abduction at all, but simply a deportation, is an assertion against his better judgment, i.e. a deliberate lie. An inadvertent false assertion can be ruled out here because this connection between the abduction and the deportation is clear from the file itself. If the Mexican police had wanted to arrest me in Mexico, then I would have had to have committed a criminal offense in Mexico or violated Mexican migration law, which is indisputably not the case. Because the BKA, working together with the German Office for the Protection of the Constitution, acting through the officer Gotz Knobloch in Mexico, and the BKA officer Monica Vasquez, wrote an email on August 24, 2023, according to sheet 131 of the main file, Volume 3. The arrest of the wanted person in Mexico is only possible on the basis of a national Mexican arrest warrant. But there was no such thing, and there could not have been, given the lack of offenses committed by me in Mexico or against a Mexican citizen and the lack of a violation of Mexican migration law. However, it would theoretically have been possible to apply for my extradition via the Mexican judiciary on the basis of the German arrest warrant. This is exactly what occurred to the BKA, because Knobloch from the BKA writes in the next sentence of the same email. If necessary, it makes sense to already prepare the necessary extradition documents in Germany. But that would have backfired on the German secret services and the German judiciary immediately, and in Mexico, i.e. at international level. Because, firstly, it would have come to light at that time, in the context of my statement on the extradition request, that the arrest warrant was without any basis, because the supporting pillar was the false assertion that I, as managing director of the company, was not authorized to act as sole director. In truth, I was, just like all the other shareholders and contrary to the allegations of the complainants, authorized to act as sole managing director. It would therefore have turned out during the extradition proceedings in Mexico that the complainants had lied in their criminal complaint. Secondly, it would have come to light that Public Prosecutor John, who had applied for the unlawful arrest warrant, had not carried out any investigations, but had blindly and willingly cooperated with the complainants and had even expressly refused to investigate my 3 lawyers. It would also have turned out that the complainants, as the court has now also recognized, had appropriated my purchase price for my Göttingen property, which among other things served to repay the loan, possibly by way of fraud, or at least without legal grounds. Above all, it would have come out even then that Public Prosecutor John knew about everything from the beginning and was continuously informed by the complainants, but did nothing about it, even remaining absolutely inactive in response to our criminal complaint of December 2023 to this day by way of obstruction of justice in office. None of this was allowed to come to light, because otherwise the behavior of Public Prosecutor John and the Federal Criminal Police Office and the Lower Saxony State Criminal Police Office, which were almost certainly working for the Office for the Protection of the Constitution, would have been exposed during the extradition proceedings in Mexico. Where do we get the certainty that the Office for the Protection of the Constitution is controlling everything in these proceedings against me? Just from the dossier? No, the file itself proves it. It contains the letter dated February 15, 2022 from the FIU, Financial Intelligence Unit, which is part of the Customs Directorate General, with which the Office for the Protection of the Constitution tried to take action against me, but then failed due to the upright and law-abiding Senior Public Prosecutor Reiner, who had the files put away in June 2022 due to a lack of criminal activity. This letter was drawn up by a Mr. Schmelter from the FIU, which is part of the Directorate General of Customs, and sent to the Lower Saxony State Criminal Police Office. It is headed, Relevance to State Security. And Mr. Schmelter claims to be an employee of the Federal Office for the Protection of the Constitution. State Security, explicitly. On page 17, he writes to the LKA Lower Saxony. For your information, I am informing you that the analysis report, this screenshot, has been forwarded to the Federal Office for the Protection of the Constitution. The next sentence proves that this was kept secret, even from other German authorities. Other domestic public bodies have not yet been informed. However, as noted, this first attempt by the Office for the Protection of the Constitution to initiate criminal proceedings against me was unsuccessful thanks to Chief Public Prosecutor Reiner. So 2.5 months later, the 3 Berlin prosecutors known to another V-man, whose name I will not mention here, came into action, filed their version of a criminal complaint on September 2, 2022. And Public Prosecutor John was transferred from Hanover to Göttingen so that Senior Public Prosecutor Reiner would not be able to stop there, the 3 Berlin lawyers, nonsense. With such a direct hit, the Göttingen judiciary with the Public Prosecutor John, who had just been transferred from Hanover to Göttingen, would have been so reduced to a compliant, Stasi-like puppet that even the mainstream media would no longer have been able to ignore it. As all this would have been revealed during my hearing in the extradition proceedings. Remember that Göttingen is described in an article in the New York Times as the heart of darkness, when it comes to freedom of expression. Because in Göttingen there were and there is a special police unit that operates undercover on the internet as if they were right-wing radicals or Reichsbürger in order to get others to express themselves in a similar way, so that you finally have a fake enemy that you can pursue. I reported on this in the ICIC video on the psychology and psychopathy of P.L. Andemia. This is precisely why the actors carried out an abduction and tried to disguise it by pretending that a deportation was taking place. Of course, there was no real deportation. This is also clearly documented in the file. Because on page 141 of the main file, the State Criminal Police Office of Lower Saxony, which is controlled by the Office for the Protection of the Constitution, writes through Lars Rogatz on September 1, 2023 with the BKA in CC to Public Prosecutor John. The current plan is to lure Reiner Füllmich to the consulate under the that he still has to correct/provide a signature on his passport and then have him arrested by the migration authorities. The words pretext and lure prove beyond any doubt that we, my wife and I, were to be deliberately deceived because of alleged passport/visa/migration problems, which in reality did not exist. In order to be provisionally arrested and to be able to deport me to Germany bypassing extradition proceedings, everything would have come out at my hearing. All this was planned by Götz Knobloch, as Lars Rogatz, LKA Lower Saxony, informed Public Prosecutor John in an email dated October 4, 2023, page 152 of the file. Mr. Knobloch has planned everything and I am confident that everything will work out. Because, as Knobloch announced on the same day, the arrest of the accused at Tijuana airport would take place in consultation with the migration authorities. A few days earlier, Knobloch had persuaded the Mexican migration authorities to fake a deportation with the help of Mexican BKA official Monica Vasquez. On September 21, 2023, page 149, Knobloch wrote, "The migration authority is therefore not a problem. In other words, my wife and I were lured to Tijuana by the honorary consul there, who in turn had been put under pressure by the German embassy in Mexico City, without any legal basis. In fact, there were no visa or migration problems. This is exactly why only I, and not my wife, was flown to Germany by two migration officials, and this bogus deportation was not paid for by Mexico, but by the clients, namely Germany, although we both allegedly had passport problems and should therefore both have been deported. However, my wife was able to fly back to our dogs the next day. I was even able to phone the consul Carlos Enkerlin in Tijuana because the whole thing seemed completely strange to the head migration officer. And he explained to me and then apparently also to the officials, in Spanish, that there was foul play going on here, but that he couldn't escape it. The head of the authority then told me, his eyes wide, that he didn't know what was going on, but unfortunately there was nothing he could do. But he wished me all the best. In the meantime, the consul Carlos Enkerlin has also apologized to my wife. In short, the migration authorities, or rather their leadership, which was put under pressure by German officials, bowed to German pressure. Without German pressure, nothing would have happened. This is once again made abundantly clear by the sentence from BKA official Knobloch to Public Prosecutor John on page 159 of the main file, Volume 3. So the migration authorities are not a problem. Why should the Mexican Migration Authority, which is carrying out a deportation in its own Mexican interests because of a migration case, pose a problem for a German authority? Because there was no migration case, but one had to be constructed at the request of the German authorities in order to somehow prevent the whole truth from coming to light in the course of extradition proceedings. The Mexican migration authorities did not pose a problem in this respect. The German authorities wanted to disguise the kidnapping as a migration case. The final proof that there were only faked passport problems and only a fake deportation can be found in the deportation order, which is certainly not by chance only in Spanish on sheet 33 of volume 2 of the file, to which the presiding Judge Schindler only referred briefly in an anxious/cursory manner, apparently hoping that no one would take a closer look or even translate it. This is because the Mexican National Migration Authority writes that my deportation is being carried out in accordance with Section 144 of the Migration Act, but without explaining which of the provisions there is the basis for the deportation. Section 144 is the only legal for deportations from Mexico by the migration authorities. This Section 144 stipulates that a foreigner must be expelled from the national territory if it can be proven that 1. She enters the country without the required documents via a place that is not authorized for the international transit of persons in accordance with para. 1. This paragraph is not given, because my wife and I traveled normally with valid German passports and were issued entry visas. According to paragraph 2, expulsion is possible if a person re-enters the country without authorization after being expelled. This option is obviously not available to us either. Paragraph 3 orders deportation if someone pretends to be Mexican who is not. This variant does not apply to our case either. Paragraph 4 orders deportation if a person jeopardizes national or public security due to a previous conviction in Mexico or abroad. My wife and I are not even close to this. Paragraph 5 orders expulsion if a foreigner makes false statements or submits forged documents or submits genuine documents that he or she obtained fraudulently. This is also not the case in our case. Para. 6 orders expulsion if someone does not comply with an order issued by the migration authority to leave the national territory. This is also not the case here. There is therefore no =0, not a doubt that there was no basis for a deportation and that the deportation order served the sole purpose of formally deceiving the authorities that there was no basis for a deportation. In other words, at the request of the German authorities, it was only intended to create the false appearance that a deportation had taken place, although in reality an abduction had taken place without any legal basis. Everyone hoped that nobody would ever check the basis for a deportation, namely Section 144 of the Migration Act, as has now happened, so that everything was blown open. Apart from that, the real deportation order would have been dealt with by putting me on the plane alone at the international airport in Mexico City. But here I was accompanied by 2 Mexican officials. And one of them, who spoke English reasonably well, explained to me that this would all be arranged and paid for by the German authorities, including the 2 flights of the officers who were supposed to guard me, which is completely impossible in the case of a genuine deportation ordered by the Mexican authorities. Supplementary: the archive of Stasi documents contains a lexicon with the following explanations of the term abduction. Kidnapping, i.e. abduction in the sense of criminal law, was an elementary component of the strategy and tactics of the GDR's secret police until the 1970s. https://www.busn-archiv.de/im-disarchicharen/stasi-unterlagen-ein/hinweis-zoom-mfs/mfs-lexikon/details/entführung/. And in the Dictionary of Political Operative work compiled by the Law School of the Ministry of State Security in 1969, the offense of kidnapping is interpreted as a form of terror crime as follows. It is the removal of people against their will using specific means and methods. Threat of violence, deception, narcotization, intoxicants and others, from their original place of residence to other places, states and territories. https://www.bunsearchiv.de/im-recherchieren/stasi-unterlagen-1c hen/hinweis-zoom-mfs/mfs-lexikon/details/entführung/. Even without including this, albeit revealing, Stasi information in the assessment of presiding Judge Schindler's assertion, there can be no doubt that his claim that a simple deportation had been carried out by the Mexican authorities is an outright lie, given the contents of the file and the deportation order referred to by Schindler. In order to deceive the public about what is otherwise obvious, the public prosecutor John, who had been specially transferred from Hanover to Göttingen, arranged my abduction from Mexico in cooperation with the services controlling him. One of the most respected German professors of criminal law, Professor Dr. C. Multiple. Bernd Schünemann, has commented on this problem in an extensive essay entitled Substantive Offense Verification and Abduction in Violation of International Law as Nation-State Explosive Devices in International Extradition Traffic, in the journal Goldhammers. Archiv für Strafrecht. 1. On page 237 he states, "It goes without saying that detention initiated by abduction is a deprivation of liberty that violates the fundamental right under Article 2, Sentence 2 of the Basic Law." 2. He then states on the same page, "Even under general state liability law, an unlawful interference with fundamental rights triggers a claim to remedy the consequences." 3. On page 229 he explains, "It is also generally recognized that the abduction of an accused organized by the law enforcement authorities of one state, here, Göttingen Public Prosecutor's Office in cooperation with the Office for the Protection of the Constitution, the Lower Saxony State Criminal Police Office and the Federal Criminal Police Office, constitutes an offense against international law that obliges the abducting state, here, Germany, to return the abductee at the request of the injured state, here, Mexico. But what if the injured state, be it out of political consideration, here, its own involvement in the abduction at the request of the German authorities, does not assert its restitution claim? Then, according to Schünemann, an effective means of eliminating this stain on the tableau of the international legal assistance relationship is to grant the abductee his own restitution claims, equals claims for damages, which must be aimed at his release, if not the final termination of the criminal proceedings due to a procedural impediment. For, after all, this is about criminal practices of the prosecuting authorities, page 237 of the essay, which, if allowed to continue, would amount to an undermining of the presumption of innocence and the establishment of the law of the fist. But not only the circumvention of the legal provisions for a formal deportation or extradition proceedings point to the involvement of the Office for the Protection of the Constitution in my case, as I have now discovered on studying the files again, the terms corona or corona reference. 2. A timely and complete hearing is the central prerequisite for a fair trial. The principle that a person accused of having committed a criminal offense must be granted a fair hearing in good time is a central guarantee of a fair trial in all civilized constitutional states. In Germany, this principle is guaranteed in Article 103 of the Basic Law and is based on the Roman legal principle of audiatur etial terra pars, i.e. hear the other side too. In fact, the right to be heard in criminal proceedings is something of a special manifestation of the right to freedom of opinion, expression and information guaranteed to all citizens in German law in Article 5 of the Basic Law as a right of defense against the state. This freedom of opinion, expression and information is the central fundamental right par excellence. Without freedom of opinion, expression and information, there is no democracy, but only lies and propaganda as tools of manipulation, resulting in totalitarianism instead of democracy. That is why all democracies have guaranteed this central right of defense of the citizen against encroachments by the state. So that the citizen is specially protected against encroachments by the state, because it has been hijacked by private corporations and/or organizations, for example. This right is also guaranteed in the U.S. Constitution in the First Amendment. Since this right of defense becomes all the more important when a citizen is accused of having committed a criminal offense by the omnipotence of the state, it is of particular importance in criminal proceedings. This is emphasized by the fact that Article 103 of the Basic Law makes it clear that the accused in criminal proceedings must, even more so, be guaranteed the right to freedom of opinion, expression and information as a right to a fair hearing, because this is the only way to ensure a fair trial in the face of an attack on the citizen by the state. This is because the only reason why citizens have transferred the right to clarify their own affairs to the state courts is their trust in a fair trial, i.e. that all parties to a legal dispute, in particular the defendant accused of a criminal offense by the state, may say and also learn everything relevant to the proceedings. However, a defendant can of course only say everything if he is also made aware of all the allegations made. This means, in particular, if he is made aware of the complete investigation file and not, as in this case, a file from which at least 80 decision-relevant notes on telephone conversations between the public prosecutor's office and the complainants and others are missing, as well as decision-relevant documents. For example, the liquidity documents of Vivian Fisher's husband, on the basis of which Public Prosecutor John closed all investigations against Vivian Fisher. A current and important example of how crucial such withholding of evidence by the Public Prosecutor's Office is the recent decision in favor of the American actor Alec Baldwin in New Mexico, USA. There, the Public Prosecutor's Office had withheld a few cartridges and not disclosed them to the defense. As a result of this withholding of evidence, the proceedings were terminated in favor of Alec Baldwin, once and for all. In short, the freedom of opinion, expression and information, which is protected in Article 5 of the Basic Law, applies all the more to the accused of a criminal offense and is therefore clearly guaranteed once again in Article 103 of the Basic Law. In my particular criminal proceedings, there can no longer be any doubt in my mind that the accusations leveled against me by the 4 Berlin lawyers were constructed at the instigation of the Office for the Protection of the Constitution. In the end, it is of secondary importance whether the hatred openly expressed by the witnesses Antonia Fisher and Justice Hoffman in court is merely a consequence of their own envy or whether, as the dossier suggests, the Verfassungsschutz used these people and their possible emotional lability with the help of undercover agents To stir up such feelings of envy and to channel them in such a way that they themselves became undercover agents of the Office for the Protection of the Constitution and would press criminal charges against me and snatch the money intended for the committee's investigative work. Since my unlawful dismissal from my own format of the Corona Committee, the two complainants have obviously not continued the investigative work to this day, and there are no plans to do so, as was evident from their testimony in court, among other things. In view of the collapse of the accusations, which were obviously false from the outset, at least for all those not involved in this trial fraud, it must have been about something other than the official accusations, namely about silencing me and thus all others who think and work like me, that is, all of us. Because what we have learned through the questioning of countless genuine, non-bought experts on the P.L. endemia, and what is now confirmed by the RKI files, has shown us all that we have been massively manipulated and lied to by bought media and bought politicians with the help of bought pseudoscientists. And since we had lost all trust once and for all, once we realized that these lies and manipulations had destructive and deadly consequences, we began to ask ourselves what else we had been lied to about and who was responsible. Those in charge knew that their house of cards of lies and manipulation would collapse when the full truth came out. Well, now the house of cards is collapsing worldwide. You may think what you like about him otherwise, but Donald Trump was right when he recently told Americans about the absolutely ridiculous criminal proceedings he was subjected to in New York City. They're not chasing me, they're chasing you. I'm just standing in the way. Now, however, panic has set in on the other side of the fence, especially among the psychopathic string pullers, because their small window of opportunity has already closed. This is why they are acting more and more desperately at all levels and making bigger and bigger mistakes. Individuals on our side of the fence have long since ceased to matter. The younger generation, of all people, who were largely asleep during the pandemia, have now also woken up to the almost insane, but in any case monstrous slaughter in Gaza and have set something in motion all over the world, regardless of religion, race, gender or nationality, that can no longer be stopped because it has now also reached the mainstream media. In an interview on the, albeit not propaganda-free, for example, the climate change panic and occasionally the virus and pandemic panic are also fueled there, TV channel TRT, on the internet, trt.world, for students from University College London, including one Jew, explained in the Bigger Than 5 section that they know that Gaza is based on the misanthropic ideas of eugenics and that this theory of eugenics was and is responsible for colonialism and almost all other forms of oppression, for example apartheid in South Africa and slavery in the USA. On YouTube are interesting interviews, for example in the series, Bigger Than 5, also on manipulation by the mainstream media with the journalist Jeremy Scahill, or in the series, Nexus, on the Olympic scandal concerning the satanic opening ceremony and the participation of an athlete convicted of raping a child. In any case, from this knowledge about Gaza, it is only a very small step to the realization that it was precisely this eugenics that was behind the pandemic that we have largely illuminated, with its goal of population reduction and complete digital control of those remaining. Then the puzzle will be complete and the whole picture will be visible, and then there will be justice. Because, as an 80-year-old Jewish psychiatrist from Canada called Gabor Mate, who survived the Holocaust as a young child, also said on the TRT channel, there can be no peace without justice. I was very impressed by the interview with him, because he also explained that we now live in a globally poisoned culture with the visible consequence that, for example, 70% of all Americans believe they have to take at least one form of pharmaceutical drug every day. And he explained that the perpetrators behind it all, if they are severely traumatized, and not, as I believe, simply born psychopaths without any human quality, cannot be cured. Because they don't want to be healed. But, he also says, it is enough for a few good people to stand up and tell the truth. And that is exactly what is happening worldwide. We on our side of the fence are doing it worldwide, and the students and now the entire global public are doing it worldwide, so that the puzzle picture is as good as complete. Back to freedom of opinion, expression and information, and the right to be heard in the judicial process, especially in criminal proceedings. In criminal proceedings, the principle of the right to be heard requires that the accused must be granted the right to be heard before charges are brought. Only if, in accordance with the Roman legal principle of audiatur et altera pars, the accused is given sufficient opportunity to comment on the accusation before charges are brought, can it be guaranteed that charges will not be brought or an arrest warrant issued in the first place. In my case, the 3 Berlin lawyers filed a criminal complaint against me on September 2, 2022 and attached a document to this criminal complaint as Annex A3, which strongly suggested that the complainants themselves were fraudsters. In my opinion, they had already embezzled client funds amounting to many hundreds of thousands of euros on September 2, 2022 and intended to access further third-party funds, namely money from the sale of my Göttingen property, which was intended for loan repayment, among other things, in the millions. If the public prosecutor's office had granted me the right to be heard in accordance with Article 103 of the Basic Law at that time, i.e. before the arrest warrant was issued on March 15, 2023, there was more than enough time for this. The criminal complaint was filed on September 2, 2022, not only would this connection have come to light. My lawyers and I would also have informed the public prosecutor's office that their claim that should not have taken out the loan because, as managing director, I was not authorized to manage the company alone was false and based on another deception by the complainants. This, together with the now proven fact that the Corona Committee's donation account was actually at risk and that the conclusion of the loan agreements was intended to secure part of the donations, as well as the now proven fact that I was not authorized to take out the loan. If the fact that I was always willing and able to pay back the Corona Committee's money had also been indisputable, everything would have become clear. 1. My actions to secure part of the donations with the help of a loan were covered by the discretion of the managing director of a company, i.e. by the business judgment rule. So that there is no basis for a criminal offense, exactly as stated by Senior Public Prosecutor Reiner 2.5 months before the criminal complaint of September 2, 2022. As managing directors, we were solely authorized to manage the company and were exempt from Section 181 BGB. A shareholders' resolution to issue loans to each other was therefore not necessary. Moreover, one shareholder always acted on behalf of the pre-GUG, which incidentally has not been officially registered to this day and also never achieved the desired non-profit status. Therefore never came into existence as a company to this day and must therefore be considered a definitively closed company. 2. The complainants are using the criminal proceedings they have initiated against me to circumvent the competent civil courts in order to obtain funds to which, in my opinion, they have no claim whatsoever in accordance with the statutes of the company and the purpose that the donors pursued with their donations, namely to promote educational work with regard to the legality and meaningfulness of the state corona measures. And, contrary to their repeatedly false claims, the company they claim to be acting for does not exist. Contrary to their repeatedly false claims, the pre-GUG was never registered, precisely because the complainants themselves, in collaboration with another alleged Verfassungsschutz v. Man, prevented the registration in November or December 2021. However, this would have meant that there would no longer have been any basis for a criminal investigation, let alone an indictment or even an arrest warrant against me. Instead, the complainants would have had to be investigated and charged, and arrest warrants would have had to be issued against them. However, those who used the puppet public prosecutor John, who was bound by instructions, wanted to prevent this. That's why he was specially transferred from Hanover to Göttingen, so that he could intercept the criminal complaint that had obviously been drawn up by emotionally unstable figures and, without even attempting to investigate, let alone grant me a legal hearing, issue an arrest warrant against me and draw up an untenable indictment against me. Every effort was to be made to prevent Chief Public Prosecutor Reiner, who had had the files put away 3 months earlier in full knowledge of all the circumstances because there were no indications of any criminal offenses, from making the same decision again and then initiating investigations against the 3 complainants, bringing charges against them and issuing arrest warrants against them. I was even denied the right to be heard at my very first hearing in Göttingen on November 1, 2023. The judge, who had already blindly signed the fake arrest warrant without any examination, judge at Moog local court, interrupted my statements with the words that I wasn't interested in what I had to say. The right to be heard can no longer be trampled on more brazenly and obviously. Because, as fellow lawyer Mirko Lawton writes on the website https://www.strafakt.de/keen-rechtliches-gehoor-im-ermittlungssaberfahren. If the court allows this treatment to pass and opens the main proceedings, it makes it clear that it, like the Public Prosecutor's Department, is not interested in a fair trial, but at best in a short trial. And so Mirko Lawton continues. It is then no longer possible to do what would have been possible with a proper and timely hearing. It is no longer possible to influence the decision of the prosecutor's office and, if necessary, avoid proceedings. This means that the purpose of the timely consent of the accused in the context of the preliminary proceedings can no longer be realized. And after everything we have experienced, that was precisely the purpose of the denial of any legal hearing and the denial of any investigation in my case, just as it was the purpose of the abduction and circumvention of extradition proceedings. Under no circumstances was the truth allowed to come out before an arrest warrant had been issued against me and I had been abducted from Mexico and I could be held in a German prison by way of deprivation of liberty. 3. Infringement of the law through the arbitrary exchange of facts and the denial of a hearing on this and on corrective statements by Vivian Fisher. Because he knows exactly that his conduct, if successful, would qualify as a crime in legal terms, namely as a violation of the law punishable by at least 1 year's imprisonment. The presiding judge at Schindler Regional Court declared on May 17, 2024 by way of so-called projection that the defense would accuse the chamber of a violation of the law and a qualified deprivation of liberty. The following can be said about this. Now that the presiding judge, because the originally charged facts have collapsed, has exchanged these facts for other, again invented facts, he can only prevent the discovery of these new inventions by 1. Abruptly cancels the commenced taking of evidence, which he himself has ordered, and 2. Does not even hear the witnesses named by us to refute the new facts and 3. Effectively excludes the public from the proceedings and 4. Without a public hearing on the new facts, a judgment was quickly pronounced against me by way of a denial of justice. In my opinion, this makes Schindler guilty beyond any shadow of a doubt of illegality. The offense of obstruction of justice is qualified in Section 339 StGB as a crime by at least 1 year's imprisonment. Section 339 StGB states that a judge, including this includes lay assessors or public prosecutors who bend the law to the detriment of a party, perverting the course of justice. However, it does not say what exactly constitutes obstruction of justice. The law has defined this. According to this definition, a violation of the law occurs when, generally speaking, objective legal rules are broken and a decision is made that is objectively contrary to the law and is no longer justifiable. By breaking these rules, according to established Supreme Court case law, the judge, or prosecutor, must deliberately and seriously depart from the law. Once again, the substitution of facts in order to achieve the desired or here presumably, demanded conviction in a different way after the collapse of the originally charged facts undoubtedly fulfills the offense of obstruction of justice. This, mind you, all the more so if the judge also refuses to grant the defendant a hearing on these new, previously uncharged facts, i.e. refuses to take evidence requested by the defense to examine the allegations now, since May 3, 2024, in focus and then also effectively excludes the public from the hearing. Throughout the entire main hearing, the presiding judge had built on the accusation of the public prosecutor's office. This cannot be emphasized often enough that I had committed a breach of trust by taking out a private loan from the Corona Committee's donations and using the loan privately, including by investing in my property. As managing director of the Corona Committee. Only when it turned out that the content of the charge was false. I, as managing director of the Corona Committee, was authorized to act as sole managing director, and when it was established in the course of the taking of evidence that My taking out a loan to temporarily secure part of the donation funds before an imminent seizure was covered by the managing director's discretionary powers and freedom of action, i.e. by the business judgment rule of company law. This accusation had to be dropped. This should have ended the criminal proceedings against me. I should have been acquitted and released immediately. Instead, the presiding judge replaced the now untenable accusations with the assertion that no loan agreements had been concluded. Mind you, they were in writing in the file. Loan agreements had been concluded. Instead, there had in fact been an agreement between Vivian Fisher and myself to the effect that the loan agreements had only been concluded as a sham transaction, i.e. with the proviso that they should not be effective, in order to conceal the fact that a trust agreement had in fact been concluded between us, according to which the money was to be transferred to another account and remain there. This new accusation is based on nothing but a mirage, because Vivian Fisher herself stated, when questioned by the presiding judge, that she, allegedly, was aware of it. Had assumed that we would both hold the money withdrawn under the loan agreement as a liquidity reserve, but that this had never been explicitly discussed. And she had also explained that transferring the money from the donation account to another account would have been counterproductive, in her opinion. And on July 31, 2024, she and the lawyer acting on her behalf, Mr. Grossenbach, were only prevented from clarifying by a muzzle from the court that there was no sham transaction agreement, but only effective loan agreements, and that there was or is no company whose shareholders could be harmed, because there were no company assets either. So that I must be acquitted immediately. The conclusion of loan agreements was also confirmed by the further taking of evidence. On the one hand, there were only ever 3 written loan agreements, which contain all the constitutive elements of a loan agreement, such as the loan amount, term, regulation on interest, repayment and specific designation of the contracting parties. These agreements were concluded between 2 fully qualified lawyers and attorneys. There are no statements to the contrary. There were no written agreements to the contrary regarding the conclusion of trust agreements or the agreement of a liquidity reserve instead, or that the loan agreements had only been concluded as a sham. Such deviating provisions would also have required written form. Particularly in the case of 2 fully qualified lawyers as contracting parties, it can be assumed that they are able to state precisely in legal terms what type of agreement they wanted to conclude. Supplementary documents or, for example, the chat processes referred to by the court do not contain any indications that the loan agreements were only concluded as a sham in order to conceal underlying trust agreements. The safekeeping of donations vis-a-vis donors does not automatically constitute a fiduciary agreement either, so there is no corresponding written agreement here either. The conclusion of loan agreements was also confirmed during the taking of evidence by the testimonies of Tobias Weissenborn, Catherine Ben, Martin Schwab and Roger Bittel as well as other witnesses from the private sphere and the committee's former accountant. Tobias Weissenborn was personally and organizationally involved in the conclusion of the loan agreements. None of the witnesses heard in court testified that there had been any talk of sham contracts or trust agreements when the contracts were concluded or afterwards, or that the parties had wanted to conclude anything other than the loan agreements presented. Moreover, the Articles of Association of VORGUG did not exclude the granting of loan agreements, especially since the company's objective of being a non-profit organization was never achieved. There was no financial loss or mere threat to the assets of the non-existent company, as the conclusion of the loan agreements resulted in the acquisition of a repayment claim both formally and materially, which would also have been legally enforceable. Sufficient property assets to guarantee the repayment of the loan amounts were available to me at all times. I had secured the loan amounts I had taken out with the equivalent value of my property in Göttingen and would have been able to repay them in any case by selling this property. I repeatedly confirmed this in numerous mediation meetings and other public statements and interviews from this period, summer/autumn 2022. This was also confirmed by the testimony of lawyer Tobias Weissenborn on the conclusion of the loan agreements and the other witnesses heard. The trial chamber also states this again in its decision of June 11, 2024 on page 4 below. The repayment of the loans was ultimately prevented by the intervention of the Berlin lawyer Marcel Templin after the sale of my Göttingen property had already taken place and the subsequent registration of the land charge assigned to him in February 2021 for a claim in a completely different amount. There was already no substantive legal claim for the land charge, as the members of the class action plaintiff group had already predominantly concluded a direct client relationship with my law firm. In addition, Marcel Templin received an amount of 1.15 million from the sale of my property, which realized a total of 1.345 million euros. As proof of this, there are written payment instructions from the notary, numerous emails, account statements, etc., which are in the file, and the questioning of the notary involved, Mr. Kleinman, and the witness Hoffman in court also confirmed this. In this respect, the Economic Criminal Chamber assumed in its decision of June 11, 2024 on page 6 that the proceeds from the sale of my property would have been sufficient to repay the loan amount of 700,000 euros at issue in the proceedings and that, in any case, Mr. Templin had no material claim in this amount. Whether Mr. Templin had a claim beyond this has no effect on the present proceedings, as further explained in the Chamber's decision. To the best of our knowledge, however, the money is still in Marcel Templin's account to this day, without the Göttingen Public Prosecutor's Office having intervened in this regard or secured the funds, despite the criminal complaint we filed at the beginning of December 2023. The defense also formally declared in writing at the end of November last year that the claim against Marcel Templin had been assigned to VORGUG in the present criminal proceedings. Just like my ability to repay, the examination of the witnesses listed above confirmed my willingness to repay. In particular, the witness Catherine Ben stated in court that it was absolutely clear that the sale of my property in Göttingen was to be used to settle the debts from the loan agreements to VORGUG. This was also confirmed by the witnesses Weissenborn, Schwab, Bittel and Kuhn as well as the witnesses from the private sphere. Even Vivian Fischer admitted this in court. This is also evident from a large number of public statements, emails, which are also in the file and were even attached to the criminal complaint, and public interviews from 2022. How, on the other hand, did the trial chamber conclude in its decision of July 16, 2024 that since the autumn of 2021, as a result of the dispute with Antonia Fischer and Dr. Hoffman in the summer of 2021, no longer wanted to repay the amounts at all to the predecessor company existing with them, so that from this point in time there was no longer any willingness to repay to the predecessor company. Is not apparent and does not arise in this form either from the taking of evidence or from witness statements or from my own admission. This statement has been freely invented by the court or any statements on the internal company disputes in the pre-GUG have simply been taken out of context. The chamber continues. The reasons why he later decided to use the amount only for the ICIC are of no relevance to the question of guilt or the question of punishment for the offenses of embezzlement to the detriment of the predecessor company. This finding by the chamber also lacks any basis and is certainly not the result of the taking of evidence, which was largely forced by the defense. Only the witness statements of Roger Bittel, Professor Martin Schwab, Catherine Ben, Tobias Weissenborn, Ivan Kunman and also, and even more so, the questioning of Vivian Fischer speak against the above misinterpretations of the court. None of the witness statements even remotely supports the chamber's assumption. Even the complainants, who had, presumably intentionally, submitted incomplete documents regarding the sole management authority of all shareholders to the Public Prosecutor's Office when filing the complaint, included my email dated August 26, 2022 as Annex 3. I already point out in this Annex 3 that my property was already being sold at the time and that I could otherwise have taken out a land charge on the property in the amount of 700,000 euros at any time to repay the entire loan amount. The loan amounts were to be repaid from the sale of my property, as was repeatedly emphasized during the process. It is particularly perfidious to conclude from the circumstances also described in court that Vivian Fischer and I had distanced ourselves further and further from the two complainants, Dr. Justice Hoffman and Antonia Fischer, from the summer of 2021 onwards. As they no longer attended the weekly committee meetings at all and had not participated in the committee's activities in any other way, that I had no longer been willing to repay the loan amounts since that time. It is true that we, i.e. Vivian Fisher and I, wanted to part ways with the two complainants and exclude them from the company by December 2021 at the latest. This did not work due to the 50:50 distribution of votes, as is already known. However, it was in fact the case that Justice Hoffman and Antonia Fisher wanted to take 50% of the donations with them when they left the company in the form of the settlement agreement presented to the court. This was despite the fact that they were no longer involved in the activities of the committee in any way, which they also confirmed in court. There was therefore no legal basis for the settlement offered. All donors also made donations for the continuation of the committee's work and educational work. This is also evident from the large Excel spreadsheet available to the court, which the committee's accountant had previously prepared. This extremely detailed spreadsheet lists every donation to the Corona Committee, no matter how small, in the amount of €5 or €10. The booking texts listed predominantly show Donation Corona Committee or Support SCA. It is therefore perfectly understandable that the majority of donors naturally wanted to support the continuation of the educational work by the Corona Committee and thus primarily the two protagonists of the committee, who essentially carried out this educational work. These were Vivian Fisher and I. However, the two complainants no longer carried out any investigative work in the Corona Committee from spring/summer 2021 at the latest. They also stated in court that they did not want to continue the investigative work. Ultimately, they have not done so in the last 2 years since my exclusion from the committee in October 2021. I, on the other hand, have repeatedly and publicly stated my willingness to repay the loan, including in the detailed program on Bittel TV on September 21, 2022, where I clearly mentioned that I would repay the loan from the proceeds of the sale of my property. In this regard, I recommend that the Chamber watch this program and hereby expressly request that it do so. To grant me permission to play the program on Bittel TV from September 21, 2022 publicly in the main hearing as part of my last word as the defendant in the courtroom as proof of my willingness to repay the loan amounts totaling €700,000, which I have consistently and repeatedly asserted in public. Of course, when I sold my property at the time, I was concerned with repaying the loan amount to Koronaosches Worschel GUG. As a lawyer, fully qualified lawyer and even DR juror, I am well aware that repayment must always be made to the original company. This was also expressly confirmed by the testimonies of Tobias Weissenborn, Ivan Kunman and Roger Bittel. None of the other witnesses mentioned in their statements that I did not want to repay the original company. The extent to which this was practically possible, as the company never had its own account due to a lack of registration and the lawyer accounts held for the donations were constantly cancelled by the banks on the instructions of the State Security Service, is another question. Even the witness Vivian Fisher confirmed that the repayment of the money took too long for her and that she, allegedly, would not have agreed to the loan amounts being secured by a collateral in the form of my property in Göttingen. However, she expressed no doubt that I wanted to properly repay the loan amounts from the property sale to the relevant company. In this respect, the court is splitting hairs, and is now again trying to foist a supposed confession on me by putting words in my mouth that I never uttered. The use of the chat with Vivian Fisher from January 16, 2021 does not support the Chamber's fictitious claim either. It quotes a chat message from me in which I told her that only she and I had sovereignty over the coal. First of all, it can be said that it is in no way comprehensible that the Chamber wants to base a, apparently firmly planned, conviction of my person almost exclusively on private chats from 2020 to 2022 between me and Vivian Fisher. The examination of witnesses apart from the witnesses for the prosecution is considered as good as superfluous, and these are only admitted by the Chamber under very limited conditions and previously narrowly defined questions, provided that the defense summons them beforehand in the self-loading procedure. Secondly, nothing can be deduced from the chat message quoted, except that it states that Vivian Fisher and I had de facto taken care of the management of the committee or the pre-GUG and had an insight into the finances because we had taken care of them. The other two shareholders, the complainants, on the other hand, did not take care of anything. This was also confirmed by the testimony of Tobias Weissenborn, who was still the account manager for VORGUG and the Corona Committee at the time, testified in court during his examination that he had actively offered to Dr. Justice Hoffman and also Antonia Fisher to be available to answer questions about the committee's finances, etc. However, he also confirmed that the two complainants had no interest in this at all and had neither approached him with questions nor with active bookings. In the end, I had actually sold my property, as I had always announced publicly and also in internal media discussions. See only Annex 3 to the criminal complaint at the beginning of October 2022. The property was completely unencumbered at the time, as was also revealed by the notary Kleinjohann in court. It would therefore have been easily possible to repay the loan to Corona-Ostjes Worschel GUG from the total purchase price of €1.345 million. As is generally known, I was prevented from doing so by what I consider to be the tortious behavior of the notifying party Marcel Templin, who obtained the vast majority of the purchase price of €1.15 million without legal grounds and, in my opinion, by deceiving the notary Kleinjohann. The Chamber has confirmed, as described, that the lawyer Templin had no substantive legal claim to the proceeds of the sale of my property, at least in the amount of €700,000. In a statement dated November 29, 2013, my lawyers also declared an assignment of the claim against the complainant Templin in the present proceedings. The Göttingen Public Prosecutor's Office is aware of the above decision by the Chamber and was also aware of the assignment of the claim to VORGUG. However, it is unknown whether and to what extent the Public Prosecutor's Office would have arranged for the funds thereto be secured to date. In this respect, we must assume that the Göttingen Public Prosecutor's Office has been aware of this matter for around 10 months, but has not done anything to secure the money to which the Corona Committee would actually be entitled. However, I am not responsible for the criminal behavior of a third party. As far as we know, the complainant Templin has received the money from my property sale, the money, which includes client funds from the Class Action Plaintiffs Association, was not even properly stored in a lawyer's escrow account, but simply in his business account. Whether the money is still there or has already been spent by the complainant Templin is also beyond our knowledge. It is questionable whether the repayment of the loan amounts to VORGUG was so important to the complainant Templin that he co-signed the criminal complaint dated September 2, 2022. Why he did not then repay the amount of €1.15 million that he acquired without legal grounds from the sale of my property to VORGUG, at least in the amount of the loan of €700,000. And why did his two partners and shareholders in VORGUG, Antonia Fisher and Dr. Justice Hoffman, not at least work to ensure that their colleague Templin immediately arranged for the loan amounts from the money he acquired without legal grounds, to be repaid to VORGUG, which was held by them? In addition, the majority of the clients from the Class Action Plaintiff Group terminated their mandate with the lawyer Templin in August 2022 and expressly and verifiably granted power of attorney to my law firm. This is sufficient for an effective cancellation of the mandate. Whether the lawyer representing the client likes the reason for terminating a client's mandate or even considers it to be the result of deception is completely irrelevant for the effectiveness of the mandate termination. In the present case, there was also no deception on the part of the client, as there had been a data protection incident in the spring of 2022 at the law firm of the Harbor Lawyers against the members of the class action plaintiff community. This was sufficient to justify a termination of the mandate with Marcel Templin for cause. Against this background, Marcel Templin no longer even had a substantive legal claim to repayment of the loan from the class action group of plaintiffs, as he no longer represented them for the most part due to a lack of effective power of attorney. Against this background, the land charge entered in the land register in favor of the lawyer Templin only 1.5 months after the sale of my property was also made without legal grounds, as he had no power of representation. The basis for the entry of the land charge was, however, solely to secure the property sold by the community of plaintiffs. Class action, loan granted. Marcel Templin was also aware of this in his actions. However, the court still avoids even looking at this second set of offenses, which ultimately prevented me from repaying the loan amounts to the Corona Committee Vorschul GUG. I, on the other hand, am of the opinion that I do not have to allow myself to be held responsible for the actions of a third party in this respect as my own culpable behavior. If the public prosecutor's office had acted in this direction within the last 10 months and had arranged for the money stored in Marcel Templin's account without legal grounds to be returned, there would ultimately no longer have been any legal grounds for the admissibility of the action for adhesion. Represented by the two complainants Dr. Justice Hoffman and Antonia Fischer. In the overall view, these facts alone permit the conclusion of genuine loan agreements. In addition, Vivian Fisher's lawyer had himself submitted an affidavit to the court in which I expressly declare and in this respect affirm in lieu of oath that only genuine loan agreements have been agreed between us. Despite the vague case law of the BGH, which serves to protect the judiciary, in my opinion this behavior of the presiding judge and the chamber does not only lead to the loss of the judiciary in accordance with Section 339 of the German Criminal Code, StGB, to an obviously wrong decision to my disadvantage because the agreements alleged by Schindler, unlike the written loan agreements covered by the business judgment rule, do not exist. Rather, this invention of new facts and the associated denial of the right to be heard is, as Schank, Schroeder, Heine put it, para. 11. An objective breaking of legal rules. So that a decision is made that objectively contradicts the law and is no longer within the bounds of what is justifiable. In this way, the presiding judge at the regional court, Mr. Schindler, is not only seriously departing from the law by committing this elementary offense against the administration of justice, as required by established Supreme Court case law, para. 12 of the above quotation, but in my opinion he is also doing so deliberately. Not only does he know this because, according to his written references, he presumably considers himself guilty of breaking the law and because pressure is and has obviously been exerted on him to bend the law, but he also knows this because we are giving him a little lecture on bending the law, including legal sources. 4. Freedom of expression and information in the battle for justice. The following statements not only shed light on what my law firm and I as lawyers have set in motion over the last 30 years, but also on the fact that, contrary to what Schindler claims, exaggerated and harsh statements are perfectly acceptable in the fight for justice. And that accusations of obstruction of justice are therefore also acceptable in my opinion, especially if such statements are made in a heated atmosphere provoked by state behavior. As a reminder, Presiding Judge Schindler began his procedural order of May 17, 2024 with the barely veiled threat of restricting the defense because of its procedural statements in these public criminal proceedings, because these statements were irrelevant and defamatory. He accused us of spreading half-truths and untruths in order to allegedly accuse the public prosecutor's office and the Court of Criminal Offenses without foundation. This, the chairman continued, served to exploit the fact that the public did not know the facts and was not legally versed. In other words, the public is too stupid to understand the difference between right and wrong and good and evil. And the public is incapable of recognizing whether the public prosecutor's office and the court are working properly or not. It could hardly be more presumptuous or arrogant. Well, it is true that, in my opinion, we have now reached a point where we must indeed assess the unlawful and unconstitutional behavior of the presiding judge at the district court, Mr. Schindler, and the other 4 judges who followed him, the public prosecutor, Mr. John, and other participants in the trial as an attempt to jointly commit a violation of the law in conjunction with a qualified deprivation of liberty. In all our statements, we rely on the fundamental right to freedom of opinion, expression and information in Article 5 of the German Basic Law, GG, and the related Article 103 GG with the right to a fair hearing formulated therein, specifically. We rely on the principles that have been developed for the so-called fight for justice by established Supreme Court jurisprudence. This case law states that even in a civil law dispute, especially if it takes place against a backdrop fueled by government action and causing public outrage, strong, even exaggerated words are perfectly acceptable, including accusations of obstruction of justice against a person. Judges. This must apply all the more in criminal proceedings, because there is much more at stake than just money. And it must be all the more valid in criminal proceedings that cause worldwide outrage due to the arbitrary behavior of the state, which is also obvious to the public. I base the following remarks on the mass litigation launched by me and my law firm colleagues at the end of the 1990s, which is still ongoing today, on the grounds of junk property financing and the resulting public outrage. The legal disputes in question concern hundreds of thousands of consumers who were deprived of their livelihoods by German banks through massive fraud. They were duped by the bank's loan brokers into buying at least twice, and often even 3 times, overpriced flats, so-called junk properties, together with full financing from the banks by way of fraud. In legal disputes and in the literature, these cases are referred to as shakedown property financing. They led to a judicial scandal that eventually exploded into the public eye and were accompanied by a media scandal that is still largely unknown today, which I will explain shortly. These disputes are still characterized by heated and tough arguments in the courts today. The following should also be added: these transactions were taken to extremes in 2007, 2008 and 2009 in the USA, mainly by Deutsche Bank, because the German judiciary did nothing to stop them, and triggered first the U.S. property crisis and then the global economic crisis and the euro crisis. At the time, my law firm and I represented thousands of injured parties against the banks, and we conducted by far the most lawsuits in these cases of shakedown brokered shotgun property financing. I heard these cases in court every day for years, sometimes even in 2 courts in one day, in the morning in Frankfurt and in the afternoon in Stuttgart. I conducted at least 2,500 to 3,000 witness hearings. That's why my colleagues at the law firm and I know very well, also confirmed by many private conversations with judges after they retired, that all the judges involved in these cases knew that the banks were lying in court and that the banking Senate of the Federal Court of Justice was bending the law to protect them. The exact details of this are very exciting, but take up too much space here. I will tell this in detail in a book. Here is just this much: I had learned that the 2 highest BGH judges responsible for banking matters were receiving money from banks for supposedly academic weekend seminars. In reality, these seminars only served to conceal the fact that in the evenings, over beer and wine and dinner, the judges and bank representatives discussed in detail how they could best overturn judgments in favor of our clients and against the banks. 2 participants in one of the seminars, a respected lawyer and an editor of a consumer protection magazine, gave me affidavits stating that these judges were discussing with the bank lawyers and other bank representatives over dinner and beer and wine in the evening, as described. How they would be able to overturn 3 cases in particular that my law firm had just won at the Bamberg Higher Regional Court a few weeks later. One of them even explained that consumer protection, an EU state objective after all, was a hydra that needed to have its heads chopped off. In a few weeks, my 3 judgments would be overturned. And that's exactly what happened. At the beginning of the 2000s, I filed a criminal complaint against these 2 BGH judges for obstruction of justice and corruption. Apparently no one had ever done this before, which surprised me when it became known. To my, now I must say naive, surprise, despite the overwhelming evidence, the charges were not even brought. Today, of course, I realized that the public prosecutors, who were bound by political directives, were instructed not to investigate. But we made sure that the scandal was not buried, but publicized, because I was very well networked with other legal scholars and lawyers, as well as media representatives. In this way, we ensured that the facts, which are still scandalous from today's perspective, became public knowledge. As a result, many respected law professors, fellow lawyers, and of course myself, but even former and active judges, to whom I had described the events, commented on them in legal journals, but also in the mainstream media and on TV. Everyone complained about the corruption at the highest levels of German courts. I was able to describe Deutsche Bank's unbelievably brazen trial fraud, i.e. Deutsche Bank's brazen lies in the trials, not only in 2 specialist articles, but also in a whole host of mainstream TV reports, and was also supported in this by a number of legal scholars. Then something happened that shook me almost more than the corruption at the banking senate of the BGH. A legendary Spiegel editor, Dr. Hermann Bott, had researched an article very well about Bayerische Hypobank, which was also deeply involved in junk real estate financing. It soon collapsed because of this financing and was bought by the Italian Unicredit Bank. A few days before his article with the headline, "An Organized Mass Fraud," was due to be published, Dr. Bott called me, completely distraught, and asked me to come to Hamburg. There he handed me the galley proof of the article, attachment, to be submitted later, and explained to me that the article would not appear in Spiegel, the most internationally respected and important German news magazine at the time. He went on to explain, when Hypobank found out about the article, because Dr. Bott naturally wanted to obtain their opinion for the article, they immediately sent a group of lawyers and marketing people from Munich to Hamburg. As a result of the discussions with the editors-in-chief of Spiegel, they bought the article and made it disappear. This is called catch and kill in the USA. Hypobank's quid pro quo for this was an advertising contract with Spiegel. In return for payment of many millions of euros, Hypobank ran an entire advertising campaign in Spiegel under the slogan, "Live, we'll take care of the details." In order not to damage Dr. Bott publicly, I did not make this public at the time, but only informed a few colleagues, legal scholars, and other lawyers whom I trusted. Because we all realized that the judiciary in Germany was corrupt through and through, at least in the key areas, we, namely a colleague from Bremen and I, finally took some of his cases to the European Court of Justice. There, after an absolutely fair and highly motivating oral hearing, the consumers won groundbreaking decisions in favor of the consumers and against the banks. However, the BGH, under the leadership of the 2 corrupt judges, refused to implement this decision. In fact, it tightened its case law even further in favor of the banks by way of bending the law. Although I also managed to publish a very extensive article on this judicial scandal in the Zeit, the control of the banking senate of the Federal Court of Justice by the banks had progressed so far that it did not change anything despite the public outrage, except that the chairman of the banking senate of the Federal Court of Justice is forever branded as a compliant puppet of the banks. But perhaps this is also something like poetic justice, i.e. equalizing justice. Against this politically, legally and medially heated backdrop, more and more court hearings took place, in which ever tougher and ever clearer words were used to negotiate and fight for justice. The most important decision for these comments on freedom of opinion and information in the context of the fight for justice comes from the Berlin Court of Appeal, C. Bwurf GE 76, 171, 193, Muller NJW 2009, 3746, 3748, which in turn relies on the Constitutional Court. The case before the Berlin Court of Appeal concerned criminal proceedings against a Berlin lawyer. As the investor's representative in a civil case, a so-called junk property financing case, he had made the following comments in a motion for recusal. It becomes clear here at the latest that the rejected judges are not objectively impartial judges at the Court of Appeal, but merely a kind of auxiliary force of the plaintiff, the bank, note by the undersigned. It has always been said of those authorized to represent the plaintiff that, due to their involvement in political Berlin, they are able to achieve things that no law firm can. Although the colleague was initially convicted of criminal offense for this statement made in a civil case, a very carefully working Senate of the Berlin Court of Appeal acquitted him and declared. Furthermore, it is recognized that in the fight for justice, a party to proceedings may also use strong, forceful expressions and striking words as professional weapons to emphasize his legal position, even if he could have formulated his position differently. See Beverf G. NJW 1991, 2074, 2075, Bayab LG NSTZRR 2002, 40, 41. OLG Hem NSTZRR 2006, 7, 8, Senate STV 1997, 485, 486. A lawyer can therefore also put forward dishonorable misrepresentations and assumptions that strengthen his legal opinion. Even if the statements, incidentally even contain the accusation of criminal offenses, e.g. obstruction of justice, it is recognized that the critic can in principle even express his criminal assessment of events as a personal legal opinion, even if it does not stand up to objective assessment. The KG Berlin, which had to review the lawyer's statements under criminal law, clarified that these were permissible expressions of opinion for the purpose of legal prosecution, i.e. in the fight for justice. In its grounds for the judgment, it addresses the particular explosive nature of the junk property lawsuits, which triggered massive public outrage, in an exemplary and differentiated manner, and explains why defamatory statements for the purpose of prosecuting the injured investors may well be appropriate. In this context, it is significant that the civil law dispute concerned the consequences of a failed construction project in which, in addition to specific insolvency law issues, the allegation was significant that the allegedly fraudulent consulting companies responsible for the subsequent financial collapse were economically intertwined with the financing bank. This constellation, which laypersons overwhelmingly consider to be obviously affirmative, but which the courts have largely rejected, has occupied the courts extremely extensively and intensively. It is a widely discussed problem of economic importance with at least 300,000 transactions, junk real estate, housing financing arranged by shakedowns, cf. BGH NJW 2002, 2336, which, due to what was perceived by some specialist literature and also the general public as one-sided harassment in favor of the banks, the, then, since then somewhat changed, cf. BGHC 168, 1, BGH NJW 2006, 1957, following the predominant case law of the higher courts. Cf. only BGH NJW 2000, 2353, NJW 2000, 2270, NJW 2000. 2268, OLG Cologne Ver 2002, 990, in each case with far afterwards, and the ruinous social consequences caused the most violent reactions for years. The choice of words was combative, exaggerated and in parts insulting. Organized resistance formed in networks against as well as a defense organized by banks for this case law, which was repeatedly thwarted by the European Court of Justice, see only ECJ Zip 2005, 1959, NJW 2002, 281, Hoffman Zip 2005, 1985. Both the judges defending them, against user-friendly courts, such as the Bamberg and Karlsruhe higher regional courts, and those attacking the legislator, an end must be put to the spook of consumer-friendly case law, quoted from BGH NJW 2002, 2336. The consumer protection laws are oil pollution of private law, in reference to Otto von Gierk's finding from 1889 that a drop of socialist oil was missing in the draft of the German Civil Code, see Bungeroth in Festschrift für Skamanski, Schutz vor dem Verbraucherschutz. p. 279, 281, as well as those arguing in favor of the affected party, Egon Schneider, Karlsruher Weißwasch, Zap 2003, 577, Glaubwürdigkeitskreis to BGH, Zap 2003, 841, readers reacting to this, interest-based lecture tourism by BGH judges, that there is an objection to traveling judges. That they get paid and that they do not do the work for which they are paid, natu. In Schneider Zap 2003, 841 inch, Der Spiegel, most reliable friend of the banks, quoted from Derleader, subprime judicator, KJ 2009, 3, 4, Derleader himself, the banking law senate under the leadership of Knob as a kind of godfather. Phase of repressive ignorance, disrespectfulness of some judges towards applicable laws, KJ 2009, 3, 7. The banking law Senate has proven to be a kind of co-player of financial capitalist risk production. KJ 2009, 3, 24, cf. Also Nassel NJW 2008, 3354, use strong, hurtful expressions to denounce the actions of the respective opposing party, which they considered scandalous, in an issue of political importance due to its social consequences. The case law cited also contributed to the private insolvency at issue in the present proceedings due to the maturity of the entire loan in the event of cancellation or termination, cf. Derleder KJ 2009, 3, 12. Deutsch, Verbraucherschutz gegen den BGH, NJW 2003, 2881, summarized the situation almost lyrically, in the rarefied atmosphere of the Federal Court of Justice, the complaints of the poor defrauded persons. In conclusion, the court states, the defendant had to be allowed to defend himself against the routine adoption of this case law of the BGH by the Berlin courts with similarly powerful words and comparisons. It's the same here. Dr. Reiner Füllmich, September 20, 2024. Page 29 from 29. Status September 20, 2024.